Thank you for joining us for Restructuring Insolvency and Troubled Companies 2025. This is episode 3, Bad Debtor Owes Me Money. My name's Thad Wilson, and I'm your moderator today. This webinar is part of the Financial Poise webinar series, Restructuring Insolvency and Troubled Companies 2025. Slides 8 and 9 of the materials provide a summary of the series, and slide 7 summarizes this episode. Speaking of the slides, you should understand from the get-go that we'll not step through those in order, nor will you have to listen to us read from the slides. This webinar, like all Financial Poise webinars, is a conversation. But keep the PowerPoint handy because I'll try to indicate what slides our conversation is touching on as we proceed, so you can take some notes. The conversation we're about to have is meant for general educational purposes and does not replace the need to consult with an attorney, accountant, or other appropriate professional. Our esteemed panelists today are Laura Davis Jones, a partner at Pacholsky, Stang, Zeal and Jones in Delaware; Richard Corby, partner at Corby Law in New York; Jonathan Friedland, a partner with Much Shellist in Chicago; and again, I'm Thad Wilson. I'm the head of the bankruptcy and insolvency litigation practice at King & Spalding in Atlanta. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us, but you can read more about us on slides 34 through 38. This webinar is a production of Financial Poise. To sign up for Financial Poise's great free weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episodes, and we'll do our best to get you an answer. And last, a special shout out and thank you to our sponsors and co-producers today, the great folks at the National Law Review, Max Asset, and the Daily DAC. There's some information about these great sponsors and co-producers in the materials. So with that background, I want to turn to Richard. Richard, how are you as a vendor supposed to track your clients' financial wherewithal? And are there some useful tools that you think help your clients detect financial distress early?
Sure, and thank you for having me on the panel. I think you have to look at from a vendor's perspective, public versus private companies. I'll start with public companies first, because public companies, by their definition, are public. They have SEC filings that they have to make. They have investor calls they have to provide, and they usually have the bandwidth to have big press releases whenever they do a deal or fire someone or whatever goes on with their company. So a few things with the public company I would look at is if you're a vendor and you haven't been paid, and say it's this is unusual for this company to pay you this late. I think the proactive steps you could take are one, check their SEC filings. Have they fired any senior management recently? Have they had to restate any earnings? Have they brought on any professionals? Have they brought on a banker, a law firm? Have they had to uh, draw down on credit facilities that they normally don't have to draw down on, or have they had to increase their credit facilities or amend them? Uh, have they Are they not paying other vendors? Have other people filed lawsuits against them? I think one of the best things to do is set up a Google alert about for whatever your customer hasn't paid you. You'll get everything under the sun, and you can even get copies of lawsuits or notified of lawsuits that have been filed, particularly if it's a landlord lawsuit, so they're behind on rent. The other point is also talk to other vendors in the space. If they're just as everybody in any industry, people talk to one another. Are they behind paying you? They haven't paid me in 3 months. And so on the public company side, it's very easy to do that. Are they paying certain vendors or not others? I think back to the Borders case, where Borders put in their SEC filings that they were having a moratorium on vendor payments, or they were paying some vendors and not others. They were picking and choosing, much like what was done in Ames. Or are they trying to are is the company trying to get out of leases or, vacate premises? Or are they doing a lot of liquidation sales? Um, that's on the public company side. The private company side is a little bit more difficult, but it's more intuitive that if they're late paying you, I mean, that's the biggest sign. Are they have they you know, cut back their orders from you? Or have they asked for less product? Have they asked for discounts? Are they doing other things that they haven't normally done recently? And I'm not talking about, it's been a customer forever. You give them, just like a law firm, you give them the obligatory 10-15% off the final bill. I'm talking, are they asking for a payment plan? Are they asking for 30% off? And or are they have they promised to pay and the wire hasn't arrived yet? So those are really the ways you can watch the signs of distress that should really perk up your antenna so you don't throw good money after bad.
If I can overlay, first of all, I
Absolutely.
don't have any idea what he was talking about when he said something of an obligatory 15% discount on the final bill. We'll leave that to the side. No idea what he's talking about. Um, uh,
The friends
he,
and family discount I was referring to. Those clients have been with you forever.
Richard did mention, watching the customer's behavior. But without trying to be redundant, unusual ordering patterns. How does AR aging compare today to historical? What about credit limit utilization, short pay behavior, all that stuff. And then if we're dealing with whether it's public or private, in terms of information that's available outside the four walls of your business, credit reports, DNBs, Experian, uh, UCC filings. If all of a sudden you see, if you're monitoring them and you see a new blanket lien being filed, that could be a red flag. And, uh, you
Empty
know,
shelves is a big one for me. When you walk in and you see the inventory really low, and I find myself acting like a bankruptcy lawyer when I go to the mall and some of the bigger stores, and you see the inventory is really thin, and you think, uh-oh, but for somebody that is a supplier to that store, that's a great way to tell it.
Yeah, well, Laura, I want to pick up on that and just open this question to you all because the economy is really interconnected and strain on one business can impact many other businesses. The types of distresses that I'm seeing in the market right now or in the healthcare space and the retail space and consumer discretionary or consumer goods. What types of distress are you all seeing and what credit trends are you seeing with respect to trade creditors that you're either working with or across the table from? Anybody want to pick that up?
I was going to say for me, I'm seeing a lot in the retail. I mean, that's not new, but still seeing a lot of distress in retail, and it shows itself, like we were saying with John, the thinning inventory, but also pushing for deposits on things or higher deposits on things you're buying, or having a much longer lag times if they don't have the goods in inventory or it's not somewhere close on the water. They're, several weeks out on the water. It's always um, another telltale sign that they're not buying a lot of stuff ahead, and that it could be a problem. So the way it kind of impacts it is you as the customer, or even as a supplier to them, you start seeing everything really slowing down, or the backup that they need is so much more than it was before.
Yeah, John, Richard, anything else to add on that front?
Sure. And just in the real estate space, thinking of residential homes that or and groups of residential homes that a debtor or a lender may have a dip lien on, you're seeing you can see when repairs don't occur as much as they did before. For instance, like the cost of lumber, the cost of cement, the cost of steel, copper, just everything to go into in electronics or just goods to put into these homes when those slow down or that they haven't been replaced in a while, it's like, oh, if they're having trouble paying the lender, they're not able to do the upkeep of property to pay, to have the floor redone or the roof done or the, stoves redone or replace the stove. So you're seeing a lot of that where it trickles it's a domino effect, actually.
Yeah. John, anything to overlay?
Nah.
Okay. So Laura, I want to ask you a question. Your customer hasn't paid you on time for several invoices, and the accounts payable from that customer are 60 days past due. Now, you being entrepreneurial went on ChatGPT and asked ChatGPT, do I have the ability to pressure my customer for payment? Because if I get paid, will that payment constitute a preference, right? And when I say a preferential payment in bankruptcy that might result in me getting sued. So should you listen to ChatGPT?
I think not. Nothing against AI. We've all used it at least to cheat for the beginning of a project. But I think in this situation, Thad, no, I wouldn't listen to them. And the reason is this. I mean, I'm a big believer in money in hand. Um, Better to have it and to have you try to come get it from me than to never have it at all. So that's first. I might actually have a valid defense to an alleged preference. But more importantly, that 60 days till you get paid because you pushed, that may become customary. That may be the course of conduct. And the next time you need to get paid, it might be 60 days again. Well, now we're starting to show a course of conduct of how long those invoices have to sit out there. So you very much might have just an ordinary course defense of that payment, of you putting an invoice out, wait 60 days till you get paid. Maybe the 60 becomes 65. Maybe there's another time it becomes 55. So if it's centering around that area, you're probably going to have an ordinary course defense. Um, but also, there could be other defenses that you're going to come up with. So definitely my view is never hold back from pursuing getting paid. Much better to try to have the money, and if you get it's asserted as a plain preference or otherwise come back at you, more likely than not, you'll resolve the matter for a lot less than 100 cents on a dollar. But also, very importantly, you might have a valid defense. So I would take the money in hand.
Yeah, great advice. So let's discuss some of the tools that creditors have in their toolbox to get paid or to protect against or prevent the impact of a customer's financial distress. And I want to start with personal guarantees. So Richard, what is a personal guarantee and how does it protect a creditor?
Sure. A personal guarantee is when it's usually the principals of a company personally guarantee a debt, whether it's a loan, a bank loan, or the uh, goods that are being sold to the company. Um, Usually, if the company goes bust, you can still go after the principal, either file a simple breach of contract lawsuit. But the danger here with personal guarantees with principals, particularly in the closed businesses, not the public companies, is that most of them put the money they have back into the business. So really, at least in my experience, the personal guarantees are kind of worthless most of the time. Uh, and also, if a principal files personal bankruptcy in Chapter 7, it's a contingent liability and will most likely be discharged in a Chapter 7. Um, so if you're going to enter into, you have a personal guarantee, you probably, I know it's going to dovetail to some of the other points where other people are going to talk about, but you probably want some backup for that personal guarantee. For instance, do they have a vacation home? Do they have um, timeshares in a condo? Do they have a luxury art collection or watch collection or anything where or could they put money aside for a rainy day fund to act as a escrow for the personal guarantee? I find all these personal guarantees, particularly if I'm representing a creditor seeking to enforce them, there's not usually much there. And if you're a company principal that guarantees it, you really don't have many defenses to them unless you were fraudulently induced to loan the money, which is a near impossible defense. So that the personal guarantees are dicey. I think you need to have, I know personal guarantee is supposed to be a security for a vendor, but you're most likely going to need more than one security on the personal guarantee.
Yeah, so it sounds a lot like a security deposit or a letter of credit, John. What is a security deposit or a letter of credit, and how does a letter of credit or a security deposit protect a creditor?
Well, everybody knows what a security deposit is, right? You rent an apartment, you got to give a security deposit. And or security deposits are not unique to residential, rental real estate. It's basically getting cash upfront to hold, which can be applied if your borrower or customer, in the case of vendors, defaults. Letters of credit, LCs, they go a step further by giving creditors a guaranteed payment from a third party, a bank. And it's completely independent of your customer, your debtor's financial condition. The word independent is important. The independent principle stands for the proposition that, so if I have a security deposit from Laura's company, and Laura's company files bankruptcy, then I have to go to the bankruptcy court if I want to try to exercise my right on the security deposit. But if I've got a letter of credit from her bank, from her company's bank, I do not have to seek relief from the automatic stay. I can just do it because of the independence principle. It's not the debtor's obligation, it's the bank's obligation. So, all sophisticated landlords these days on the commercial real estate side, they require letters of credit. They don't take mere security deposits anymore.
Yep, that makes a lot of sense. So Laura, a close cousin of that is just a security interest in collateral. So what is a security interest in collateral, and how does a security interest in collateral protect a creditor?
A security interest is just that you're getting a lien on assets, so you have some collateral to back it up, or back up the payment. So that's a good thing as long as the value is there in that collateral. But there might be, several other people that have liens in that collateral ahead of you. And the collateral, like I said, it's only as good as the value. So if we're all leaning a house and the house is worth 200,000 and there's already 180,000 of liens on the house and you're owed 50, then you've only got allegedly protection for 20,000, which isn't going to take you very far. I mean, I really come back to John in the letters of credit as I think about it, as I'm spending more and more time in this industry, that I can't understand why you would do anything but a letter of credit. And it's easy for me to say, because a lot of times folks just will not issue them. And I'm in a situation right now where the numbers that we want to have protected are so large that the company is saying, you just don't understand. A letter of credit we cannot do because we have to fully cash collateralize it. Just like John was saying, if I call on the letter of credit, the money has to be there. So most banks aren't going to take your word for it. They're going to make you fully cash collateralize that letter of credit. But in something that's in a reasonable level, a reasonable number, it really does seem to me that the letters of credit are the ways to go. And I've seen that more, that just in the last 6 months with how kind of indeterminate the economy is right now. And there's a lot of people pushing for LCs, and I'm starting to really see why they are. But back to my subject on the security interest in the collateral. Again, it's better than having nothing, than just a promise. But again, you have to be careful to see what that collateral is that you're being given a lien in. I mean, if it's already leaned up and there's no equity in that collateral, it's not going to help you any. If it has other risks to it, then it could be difficult. But there are situations, and we've all seen it, where note holders, others have had collateral or liens and receivables, and they've actually ended up, even when the company's going into bankruptcy, they're still oversecured, that they don't have any risk. So the key is really, in evaluating the collateral that you're being offered or that you're demanding.
Yeah, totally agree. And one other thing for the audience to keep in mind with collateral is, and making sure that you've got the appropriate documentation and paperwork, right, to ensure that you're secured in that collateral, because you might actually have a grant of a security interest, but if you haven't properly perfected it and the company goes into bankruptcy, then you're just in the same unsecured position as you were before you got the grant of the security interest. So just a really important thing for the audience to think about.
And an obvious nightmare scenario is you intend to get your UCF filed, yet you have every good intent to do it. All of us are way too busy, and it just doesn't get done. And then eventually you get to it. But then the company that you had the collateral from files bankruptcy within 90 days, and you're back to the preference actions that Thad was talking about earlier. And now you very likely are going to be seen as somebody who was preferred over other creditors. You were given collateral when others were not. And that lien is going to be worthless to you.
Yep. Totally agree. Totally agree. So, John, what about consignment arrangements? We hear that from time to time. What is a consignment arrangement? How does that protect a creditor?
Well, let me tell you a story.
Uh-oh.
So let's say every morning I wake up and I go to my backyard hen coop and I pick out eggs and I go to my local general store. You're wondering where I live probably, but that's a whole different story. And I sell my eggs to the general store and I sell on credit. And the general store actually owes me right now for the eggs I sold it over the last few months. They owe me a few months worth of purchases. And maybe the general store sold some, but maybe it had to throw some away. Maybe some broke. Doesn't matter to me. I mean, they got to pay me. I sold them the eggs. They owe me the money, whether they broke some by accident or if someone spoiled before they could sell them. But the problem is if the general store has financial issues and I'm left just being owed money as a general unsecured creditor, I'm last in line to get paid. Contrast that to a reality where I still go and get the eggs and I bring them to the store every day, but I'm not selling them, I'm consigning them. I'm giving the eggs to the general store to sell on my behalf, but I continue to own the eggs and the vendor or the general store doesn't have to pay me, isn't obligated to pay me unless the eggs are actually sold. And so after the sale, I keep what I'm entitled to, and the vendor keeps the rest. Now, if you do a consignment arrangement correctly, that's good protection, a perfect protection if it's done correctly. To the case of a company where the company if a company becomes insolvent and can't pay its creditors, I'm not a creditor. If it's holding money that it owes me, it's holding my money. It's holding it in trust for me. Would be the argument. The problem is in real life, it's difficult to do it correctly. And that means primarily under UCC Article 9, most consignments are treated like secure transactions. So if the general store has a blanket lien, then I better go to the secured lender that's senior to me and tell it that, hey, I'm going to have this consignment relationship, and I need to give it notice before I start doing that, or the secured lender will say, no, that's my collateral, and the secured creditor will win every time if I don't do that right. And even if I do that right, there's a practical problem with respect to commingling of goods. Basically the concept of secret assignments, where if a lender goes in and the lender can't tell what's what, it gives the secured lender an argument that how could I possibly have known about that? There's a concept called ring fencing. I think it's called ring fencing, where in order, even assuming you do your UCC stuff correctly, the legal paperwork correctly, it's still best practice if you can to keep your stuff segregated from the rest of the inventory if we're talking about a store. So I had a debtor client a while ago as a chain of retail stores, and they had a little section that was behind glass were the products, and very clearly it was labeled that these are the products of so and so. That's pretty good. That's a good way of doing it.
So it's the store within a store concept.
Store within a store. And you also, people talk about consignment mostly in the retail context, but it's also in the manufacturing context where I've walked into factories of my clients where talk about the term ring fence. There's literally an area of the factory floor that is fenced off from the rest. And there's a vendor there who is basically selling stuff to the company that whose factory it is as necessary. And it's or just yeah, and so that's that everything in there is consignment. Anyway, I think I covered it enough.
Yeah.
Yeah.
No, that's very thorough. Richard, what about cash on delivery and cash in advance? This kind of goes back to what Laura was saying earlier. She'd rather have the cash and then fight about it later. So what are cash on delivery and cash in advance, and how do those protect creditors?
Sure, they are what they say they are. Cash on delivery means you get the cash as soon as the goods are delivered, and if they don't, if the uh, company doesn't pay right then and there, you don't have to deliver the goods. Cash in advance, they have to pay for the goods in advance. You have the money, and to get back to what Laura was saying, it's always much better to have them come after you to get the money than you have to go after them. I think everyone on this panel has tried to get money out of a debtor or some entity for their client. It takes forever, and the client wonders why. Uh, again, you have that security blanket that you have the that you're not going to be throwing good money after bad, and with cash in advance, you don't have to worry about getting the goods back because you already have your cash for the goods. Cash on delivery, if they don't pay, you're not out the goods. You don't have to drop them off at the company. You can take them back, so you're not out, the money and the goods.
Good. Well, here's one for all of you. What is credit insurance? What is that about? How do you get it? Does your credit insurance just pay you if your customer doesn't actually pay you? What are your thoughts on credit insurance? Anyone?
Well, I'll jump in. I'll jump in first. Credit insurance is what anyone would probably guess it is. Basically, it's insurance. If you're a vendor, a seller of stuff to another business, you can take insurance out to protect you against the risk that that business, your customer, does not pay you. It sounds like a guarantee of the debt, but it's not. It's conditional. You have to follow the rules set out by your credit insurer. The bottom line is the big picture. I've got clients, they have credit insurance generally, but that doesn't mean every single one of their customers is covered. They have to, once they have the relationship in place, then they need to proffer each customer for like individual underwriting to the insurer. The insurer will say yay or nay and how much I'll insure you to. And as a matter of fact, some of my clients that sell B2B, they will, they'll give credit terms to a customer as long as they can get credit insurance on them. And if they can't, they sometimes won't, or they'll give very strict credit terms of their own to their customers, stricter than if they had the insurance. But like I said at the outset, the credit insurer requires it's insured to follow a lot of different steps to make sure that the insured doesn't make a bad situation worse by taking a misstep. So you really have to dot your I's and cross your T's when you're utilizing credit insurance. And it's an area just like the traditional or the broader insurance market. It's an area where the insured, it relies on having a good credit insurance broker as a practical matter, both to find the right insurer, but also to help make claims.
Yeah, great explanation. All right, so
I was just
Lori,
gonna
were you
ask that,
jump in? Yeah.
is that credit insurance, John, is it usually expensive? Because that's what you always, that's always kind of the rumor on it is you don't use it because it's expensive. Do you have any feel for that?
I do. In my anecdotal experience, it's not expensive. If you're, if it's like anything else, if you're trying to get it on a customer that is known to be very much in distress,
Right.
then yeah. But if you're using it, I've got clients, they're manufacturers, they're service providers, they use credit insurance every day, all day. And they view it as I don't know if they call it a bargain, but they view it as a good use of their money.
Yeah. Okay. So Laura, just want to switch gears slightly, or really wrap up this portion of the webinar, which is to ask you, in your experience, do you see customers typically agreeing to the kinds of preventative measures that we've just been discussing, right? Debtors, people on the precipice of filing for bankruptcy, are they going to agree to guarantees or letters of credit or cash on delivery or cash in advance? What do you see out there?
Well, I kind of look at it from both sides. From in terms of the people that should be looking for some type of safety valve, that they should be looking for deposits or they should be looking for cash in advance, that type of thing. I find that no, usually people start doing that a little too late. And I think part of that is just human nature, Thad. We all like to be trusting. We don't want to accuse the business relationships we work with that somehow they won't pay us or they won't be honest with us, and we're afraid it's going to damage that relationship. Um, it's like we were talking about before. We're all probably not aggressive enough at using the colloquial pinging people to get paid, and finding ways to do it. On the other side, in terms of guarding against what's going on, no, again, usually we all stay in denial a little too long. And then by the time we realize there's an issue, it's never too late. I mean, it's always possible that there'll be a remedial measure you get and it'll fix itself. You caught it in time. But I think that to answer your question directly, usually I find that people do not use the preventative measures fast enough.
Yeah, that's my experience too. John, Richard, any different experience than Laura's and mine?
It's about the same. I mean, because it's a confidence and trust drive all business relationships. If you start accusing someone of, lack of a better term, of being a deadbeat, they could take it be really offended and say, "Oh, we've done business together for all these years." It could be insulting. But I think there's a way to do it, and I've done this again. Again, too late, as Laura said, in one matter where it was a public company, and I said, "Look, we're seeing all these reports. Looking at the SEC filing, it's not you, it's just the entity as a whole." But again, it's usually too late when people do this. And again, if you have to get paid earlier and you run the risk of preference exposure, so be it, because it's better to have your money now than be chasing it.
And I saw even with law firms that I hadn't really thought about this too much, except we all have in there, if we don't get paid, that's a basis on which we could terminate the relationship. And it's kind of discretionary and it's kind of out there. We don't really delineate what the when and how. And I got one the other day where they literally had built in there, and it was just a form letter. So maybe you could say, I somebody wouldn't take it as personally, where it literally said non-payment of this invoice in 30 days, like one reminder or something like that, in 10 days, our relationship is severed, which I thought was pretty aggressive for a law firm, because some of us
Yeah.
work pretty hard to get those relationships, and it might be hard to do. But depending on the situation, that might be one way to do it. Is it's just built right in that boilerplate. I suppose you could choose to waive what you said you were going to do, but you'd want to be careful in how you document that. But I am starting to see that more, and to see that in a law firm letter, I thought was interesting.
The other
That-
side of the coin, so far we've talked about whether the vendor is willing to ask for this kind of stuff. But then the flip side is, okay, let's assume the vendor asks. How often do the customers say, okay? And that really is, it's industry specific, it's situationally specific. If you're doing business with any of the great big tech companies, Facebook, let's say you're a supplier to Facebook. I don't think Facebook is going to offer up, the guarantee of Mark Zuckerberg, and they're not going to agree to anything else. They're Facebook. Everybody wants to do business with Facebook. There's that sort of thing. And then in terms of industry, if you're a commercial landlord, if you're looking to lease space from a commercial landlord, good luck finding any commercial landlord that will not require an LC. So every commercial landlord, is comfortable that of course they can demand one. On the other hand, the idea that your widget maker is going to demand an LC, that's pretty uncommon. It's probably going to be a very special sole source widget maker that has that kind of leverage to make that demand.
Yeah. Yeah, very astute points. And one other thing that, I would just raise for the group, and a trend that I've seen over the last several years, and it really started with Toys R Us, and from there, right, was that, a lot of people trusted Toys R Us, and the management team at Toys R Us. Big company, lots of locations. How on earth could Toys R Us fail and not pay us after the bankruptcy case? And so a lot of trade creditors trusted, I think, the management team, and the financial advisors and the lenders inside the bankruptcy case to otherwise ensure that the company was going to continue paying them. And when that didn't happen, and it created what we call administrative insolvency, I've seen so many trade creditors, particularly in the retail space, over the course of the last five or so years, start putting clients, customers of theirs, on cash in advance or cash on delivery, fairly early on, which then exacerbates issues, for the retailers who are trying to stay afloat and need the credit from their vendors to otherwise, keep goods in their stores. So there's kind of the ebb and flow and the give and take, but that's one that I've seen that I think is a trend, at least in our space, where we see a lot of cash in advance, cash on delivery in the retail sector in particular. All right, to completely, go in a different direction, right? So we've, tried to implement all these. No one reached agreement. Couldn't get cash in advance, cash on delivery. These, couldn't get a LC, didn't get a guarantee. Customer ends up in bankruptcy. So I want to talk through a few basic aspects of a voluntary bankruptcy. Richard, what is the automatic stay, and why is that important for creditors?
Yeah, the automatic stay is acts like and is pretty much an injunction. Once the debtor files Chapter 11, it bars creditors from starting actions to collect on their debts or continue actions to collect on their debts. There's a few exceptions in the automatic stay, but most of them aren't applicable to vendors here. It means, even if you've delivered goods a month before Christmas, as we're getting into the holiday season, and they filed bankruptcy right at Christmas, you can't go get your goods back to give to another store to sell at Christmas time. You'd have to do what they call file a motion for relief from the automatic stay, to either get your goods or get the money back for your goods. Now, generally, in the beginning of a case, those will never be granted by a bankruptcy court because the automatic stay is designed, the company filed bankruptcy for a reason. That you're not the only creditor they owe money to. In fact, you may be further down the line in terms of where you sit on the capital structure or the claim structure of the debtor. You could sit behind, you're most likely going to sit behind the lenders. There's bond debt or other sorts of debt. And the automatic stay, you're kind of stuck with the debtor filing bankruptcy and you can't go get your goods. Or I strike that. There are certain situations that we'll talk about later where you can make a request to get your goods that won't violate the automatic stay. But generally, just sending a threatening letter, especially if you've known about the bankruptcy, if you get notice of it, if you usually give out notices to all your creditors, or if you already have a lawsuit going on, the debtor has to file a notice of suggestion of bankruptcy on that case docket, whether it's state or federal court. Or if they tell you, or if they send you an email and you continue to collect, not only are you out your goods and out your money, but the debtor could turn around and sue you for damages for not only violating the automatic stay. And a lot of the case law, I mean, vendors do get hammered for stay violations. They can't say, "Oh, I didn't know, I wasn't aware, but you're did get you got a notice or some notification of the bankruptcy filing." So really, all that what the automatic stay does, it creates a moment in time where everything stops and there's a bankruptcy estate created. And now think of the estate like a pizza pie. We're going to be cutting up that pizza for slices. Not everybody's getting a slice. Some people may get a small slice. Some people may just get the empty box at the end of the case. So it's really important. And this gets back to what we were talking about earlier, even if you have to take those aggressive terms pre-bankruptcy, cash in advance, cash on delivery, security deposit, or just pressuring and hounding the company to pay you, you're better off there having the money than dealing with the bankruptcy.
So Laura, Richard mentioned stay relief. What is stay relief? How do you obtain it?
Well, what Richard said, with respect to the automatic stay is correct. It's kind of like a wall goes down to try to give the debtor a breathing spell to try to restructure or figure out what it's going to do. And you cannot go ahead and sue them or do anything else for any claim that was brought or could have been brought before they filed bankruptcy. So if you say, look, I've got a lien in their collateral, but it's dwindling. It's like I have a lien in a car that's losing value on a daily basis. So they don't have any way of really protecting my lien, of making sure that I'm protected. So you could move for what's called moving for relief from the automatic stay so that you could repossess on that car. And you would argue that you've got cause because that car is not, the value of it's not being protected, so your lien is devaluing as we speak. Or you could try to go the route of saying, well, look, the debtor doesn't have any equity in that car anyway. It's already leaned up by everybody. And that car is not going to be necessary to get this bankruptcy done. So, Judge, you should give me relief from stay for them to try to sell the car. Maybe I can get the lien holders ahead of me to take less money, and I'll get something out of that car. But let me try to do something, Judge, because we're sitting here and the thing's devaluing and or the debtor's not going to use the car anyway. Courts are, and Richard's right about this, courts are reluctant to do something about that too soon. If they just filed bankruptcy, the court might say, hey, let me give them the breathing spell they deserve. Let me see what we can work out, and we'll come back to the car in a couple of months. And my view on that is, even if you think you're not going to win, it's very possible you're not going to win. I would go ahead and get that motion filed, get your story out in front of the court, let the court say no to you. And then when you come back in 30 days, much more of a chance, if things haven't really changed, much more of a chance you're going to win it the second time. So you kind of have to, in these type of situations, so I think everybody has said this earlier, sometimes it's painful, but you have to look at the bigger picture. Not try to win every battle, but you want to win that war and get your money back.
Yeah. Well, you mentioned, Laura, the declining value of the collateral, right? And
Yes.
that dovetails with something, in the code that's called adequate protection. So I want to ask John, what is adequate protection and why is adequate protection important?
So Laura is generally a very impressive person, but in particular, I'm really impressed how she was able to describe stay relief without uttering the words adequate protection. I think she did that with great intent.
I did.
When Laura referenced, she said words like the value of the car is not being protected, it's devaluing. That was Laura affirmatively avoiding the use of the defined term adequate protection. So as not to, I think she knew this next question was coming to me, so thank you. In bankruptcy, adequate protection is, as Laura suggested, it's the way the bankruptcy code protects secured creditors from being harmed while the debtor continues to use their collateral during the case. And to tie, to connect dots. So the automatic stay, as we've discussed, it stops creditors from repossessing or foreclosing without lifting of the stay. So the code to sort of make up for that requires that the debtor preserve the value of the creditor's collateral. And it's the form of that preservation is what is adequate protection. And adequate protection can take several forms. It could it could be cash payments to offset the depreciation or the use of the collateral. It could be replacement liens on different collateral. And it could be a whole sort of other, creativity is our only limitation. It could be other stuff.
Yeah. Well, that's very helpful, John. And adequate protection is really a complex subject. And even a lot of bankruptcy lawyers and bankruptcy judges have a hard time defining it, particularly in that last category, where you're trying to define the other stuff or be creative about what the adequate protection should be. Just a real quick follow-up question: do unsecured creditors get adequate protection?
No,
Okay, and why is that?
they just don't. Because what's the best way to articulate the answer? They don't have the adequate protection is there to protect the value of the security. The secured creditor has bargained
Right.
for a lien on particular assets. The unsecured creditor has not done that.
Yep.
So the concept just doesn't apply.
Got it. All right, so Richard, do you want to walk us through at a very maybe quick pace claims classification and priority? What in a bankruptcy case, what is the priority scheme that's applicable, and how do claims get classified?
Sure, I'll keep it very simple for this discussion. There's the secured, usually there's a waterfall of just claimants who get paid first, second, third, fourth, and in numerical order. And you have your secured creditors who are getting paid first. They are first in line, ahead of general unsecured creditors, which are the vendors, but there are some sub carve outs for those, which we'll touch upon later. So you have the secured creditor, which really runs the show in the bankruptcy case, and the next set of creditors you have, well, actually, they're not really classified, but you have administrative claims, which are administrative claims that arise during the bankruptcy case that have to be paid no matter what. And those can be professional fees. Those are landlord claims, vendor claims. If you shipped goods post petition, that's an administrative claim, although there could be arguments that it was entered into pre-petition. Again, I won't get into the weeds on that. Basically, anything during the bankruptcy case is administrative and has to be paid. Those include U.S. trustee fees as well. And then you have priority claims, which are wages, utilities, and you have certain general unsecured creditors, which we'll get to later. But your priority claimants are usually the wages, taxes, utilities, and those have to be paid because, especially if it's a wage claim or a tax claim, the taxing authority could sometimes prime the senior secured lender depending on what each state statute says. And then you get to, you have your group of unsecured creditors, which include your vendors, but it could also include your lender if if they're not fully secured and they have, we'll use the $200,000 example from earlier. If they're only secured for 200,000, but their claim is 250, then they're going to have a $50,000 deficiency, and that unsecured claim will be put in the general unsecured class, and usually they dwarf the rest of the unsecured creditor body. And after the unsecured creditors, you have equity holders, which usually get wiped out and do not receive anything in a bankruptcy.
Yeah. All right. And Laura, real quick, there's what's called a proof of claim process in the bankruptcy case. It's the manner in which, creditors get paid. Can you just describe that real quick for the audience? I'll reference 28 and 29 of the materials.
Sure, it's probably one of the most important things you can do in a bankruptcy case as a creditor is just get a claim on file to show that you're owed money. Attach whatever documentation you have that demonstrates that that money is owed to you. If it's not sufficient information, they could ask for more information. Your proof of claim is deemed prima facie valid, and then the burden shifts and they have to show why it's not. They being the company in bankruptcy has to show why it's not valid. So you want to get it on file. And one of the things, a mistake I hear a lot of people make is they said, that notice came in the mail. I waited for the notice to come. It came and it's sitting on the dining room table somewhere. What you really need to do is if you hear a company files, just go ahead and file the proof of claim. If you file it with the bankruptcy court where the case is filed, even if they have a claims agent or someone else that's collecting the claims, if you file it with the court, it's deemed filed. So you just want to get it on file. You can always supplement it. You can always amend it. You can always correct it. Not add new theories. You got to get all your theories in the first time, but it's probably one of the most important things you can do in the case, because like the Richard and Jonathan were saying earlier, sometimes value comes out of who knows where for the unsecured creditors, and you want to be able to share in that.
Yep. Agreed. All right. So, I want to talk just briefly in the 10 minutes or so that we have left about, some things that trade creditors might hear about inside of a bankruptcy case or once a bankruptcy is filed. And I want to start with slide 15. And John, what is a prepackaged bankruptcy? That term gets thrown out there a lot. So what should a creditor know about a prepackaged bankruptcy?
Pre-pack is a Chapter 11 where the company, i.e. the debtor, negotiates and secures creditor approval, the necessary level of creditor approval for a Chapter 11 restructuring plan before it actually files for bankruptcy. And because the key votes are locked in, and they are locked in legally by agreement, written agreement, the court process is a lot faster, less expensive, more predictable than the other types of Chapter 11. And the biggest takeaway for a general unsecured creditor, if the pre-pack is successful, I think it's antithetical to the idea of a pre-pack that general unsecured creditors would be forced to take a haircut. Laura, have you ever seen anything like that?
No,
Yeah.
John, they're usually just frankly out of the process and they keep riding through, like the bankruptcy never happened.
Yeah, I mean, I think that would not even meet the definition of a pre-pack anymore.
I think that's right.
Yeah, so that's the big takeaway. General unsecured creditors can, breathe a sigh of relief. Although I suppose if a pre-pack falls apart, then those bets are off.
Yeah. All right. So if it's not a prepackaged bankruptcy case, then it's a more traditional Chapter 11 reorganization. If it's not a Chapter 7, which is just a straight up liquidation, I really want to focus on a Chapter 11 reorganization. and some of the considerations that creditors should be aware of. These are really mentioned on slides 23 through 29 of the materials. Richard, I want to start with you. What about reclamation claims and 503b9 claims? What are those, and what should creditors know about them?
Sure. The reclamation claim is basically the goods that a creditor delivers in the ordinary course, and within the 45 days of a company filing bankruptcy, they can demand to have those goods returned to them. However, this usually is worthless because a debtor usually has secured creditors who've leaned up the entire company. They've leaned up every asset receivable, and so you're a allegedly you're a secure, air quote, secured creditor who's sitting behind the first lien lenders. So it really doesn't have a lot as much value. But generally, if you should file the reclamation notice to get it on file, to get as Laura said, to get your story out there, to say, hey, because you're not the only one. Because what's going to happen as soon as one or two creditors file it, they're depending on the size of the company, 20 or 30 letters are going to be filed on the docket by creditors demanding their goods back. And what that will do, that will force the debtor's senior lenders to negotiate and say, oh, we have to leave something here. We have to deal with this issue. We just can't flush these creditors. And that dovetails into 503b9 claims, which basically it's a fictional administrative claim that occurred pre-petition. So in the 20 days prior to the company filing bankruptcy, goods that were delivered in the ordinary course have to be paid. Those goods, those 20-day invoices have to be paid. Now there's a lot of nuances of receipt, if there's drop shipment, if it's actually a good, is electricity a good, is water a good, but just keeping it simple for this panel, it's goods delivered in the 20 days. It's pre-petition, which normally would be a general unsecured claim, and you sit behind the senior secured administrative and priority creditors. You become a priority creditor that has to be paid as it exits bankruptcy. And a lot of judges, require the debtor to, quote, pay the freight. If the lender wants to drive the process, they have to pay for these 503b9 goods. And the reason why I can't believe it's been about 20 years since this was added to the bankruptcy code, but I get back to my Christmas example since we're in the holiday season. What a lot of vendors would do is they deliver product to a retailer leading up to the holiday season, and then either during or right after the holiday season, file bankruptcy. And you, as a vendor who just closed out the calendar year, shipped all these goods, and now you have a receivable that you may not collect on, or you may collect a portion of. And oh, by the way, if you receive payments on other goods you shipped, you could be exposed to a preference lawsuit. So this was sort of the bargain that the trade creditors are able to have now with the debtor. And sometimes, and I've done this in debtor cases before, sometimes if you know you're not going to have enough money, sometimes you don't accept goods 20 days before the bankruptcy, so you don't have to worry about this issue. And that requires strategy and timing and all that sort of stuff. But the 20-day 503b9 claim is essentially a fiction that turns a pre-petition general unsecured claim into a priority claim that has to be paid during the bankruptcy. It means you're on the same level as essentially the other senior creditors, such as the lenders and the administrative creditors.
All right. So the last thing I want to end with, Laura, is we hear a lot about critical vendors or critical trade status. What is a critical vendor, and how should our audience think about becoming a critical vendor in a bankruptcy case?
This is an affirmative action that a trade creditor takes in a way to try not to get stuck in the ways that Richard talked about. And where it used to be fairly unusual, it's really now becoming quite a business tool. And what it is mainly like in manufacturing debtors, where maybe you're a sole supplier of a custom product they need, or you're somebody that provides product on a time frame that nobody else can really produce and deliver as quickly. You just say, look, I'm not going to be able to keep working with you after the filing unless if they're gonna make sure I get paid. I just can't. And what they'll do is they'll put you on a critical trade list which will say things like, if you pay us, if you supply to us, we guarantee we will pay you within X date. Usually the trade is some type of terms that you'll provide as compared to the cash in advance we were talking about earlier, or the cash on delivery. And as long as they stay within those terms, you're supplying product and you're getting paid. What's interesting now is a lot of times you go into a bankruptcy and it's the debtor who's coming to you and saying, I want you to be a critical trade. Where I'm seeing a lot is in the automotive space, where I'm representing some of the larger suppliers. And we can't, we have just in time manufacturing going on. There's some product we just can't get from alternative sources. We can't stand around and negotiate with you of whether you're going to provide it or not. So we come to you and say, look, if you keep providing it, we will give you 15-day terms, or we'll give you 10-day terms, or whatever it may be. But we just need you to know you're going to keep providing it to us.
That was a great explanation. And thank you, panelists. I hope you've had as much fun as I have today. I feel like we could probably go another hour.
Definitely.
But for the audience, slides 5 and 33 both remind you that you cannot go out and make important decisions based on what you learned, if anything, in this webinar today. We're not your advisors. You're not our clients. And this stuff was really meant to give you general knowledge to help you select and work with advisors, including the 4 capable lawyers that are here with you today. This concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. Thanks, everybody.
Thank you.
Thank you.